Good afternoon. Thanks for joining. My name is Lluc Cerda. I'm here to answer your questions today on behalf of Samfiru Tumarkin. I'm a senior associate at Samfiru Tumarkin's Alberta office and the managing partner of our Calgary office. Thanks for joining us today. I am traveling today, which is why some of you who are regular viewers of the show might notice that my background's a bit different. It's summer vacation is upon all of us, and it is for me as well. Actually, I'm back home in my part of the country, and I was speaking to an acquaintance recently about their employment rights. And reminded me to remind everyone here today about what your severance entitlements mean. So my friend was asking me, how much severance are we entitled to? Is it 2 weeks per year, 3 weeks per year? If you've watched the show before, you know that it's not that simple. All right. There's a lot of factors that go into determining how much severance someone is owed. It could be generally around a month per year of service, sometimes even more. There's an upper maximum in Canada of how much people are usually entitled to receive, which is up to 2 years of severance. So when you're looking at severance, you're basically looking at four main factors to determine how much severance someone is entitled to. Those are your age, your length of service, how long you've worked for the company, the kind of job that you have. The more senior the job, the more severance you're usually entitled to, and what kind of job market you're being returned to. If there's a recession or something like that, it might make your severance entitlements greater. But we have tried to make this as simple as possible for you, and we have a great tool on our website that allows you to find out for yourself, confidentially and with no obligation, how much severance you may be entitled to. You can visit pocketemploymentlawyer.ca. Pocket Employment Lawyer, we have the website address here on the screen, and we have a severance pay calculator on there where we can look at your specific features and give you an estimate of what we think your severance entitlement should be. I refer to that tool a lot when I'm speaking with people that want to know how much their severance might be. Feel free to use it, free of charge, confidential, no obligation to use it, just so you know how much we're talking about. All right, because it can be quite a bit of money. I have people that come to me, they've been offered a week per year of service, maybe two. They think, oh, maybe that's not a bad deal. It could be a lot more. All right, so it's very important that you know what your severance entitlements might be, because you've just been terminated. You have to make some important financial decisions and important decisions about your future, and severance is one of them. So it's very important to know what you're entitled to. We have a question coming in today from Black Alley Cat on YouTube asking, I have been told the company is closing in 12 months' time. Is this considered verbal notice? Am I not owed any severance in this case? So essentially, the thing about severance, what you need to know is that severance is there for people who are terminated immediately. All right. The employer is allowed to tell you, listen, I've looked at the Samfiru Tumarkin severance pay calculator. It says you're owed 12 months of severance. Instead of paying you a 12 months lump sum, what I'm going to do is tell you 12 months in advance that your job is going to end. So it's absolutely legal. All right. So long as 12 months is enough severance, that's absolutely legal. And so long as they don't change their mind, right? If they say in 6 months from now, well, actually, we're going to terminate you in 14 months from that, right? And then they keep on changing the termination date to the point that you don't know when your job is going to end. That could end up basically nullifying their notice. All right. So if they're changing the date, and all of that, then get in touch with us. It might be that they've nullified their notice of termination, and then that when they do terminate you, you're again entitled to receive your full severance entitlements. But yes, it is theoretically legal to provide you with what's called a working notice. So instead of a severance package, to have you work out that period that your severance should be. And then at the end of it, then you're terminated without any further compensation. Absolutely, that's legal. We have another question coming in from Simply Uquine on YouTube. I think Simply Unique, maybe. Unquine. I was fired from my job without cause after 15 months of service. I worked overtime daily and dealt with workplace harassments. What are my rights? Great question. You have a few important rights, simply Equine. You can, of course, pursue the unpaid overtime that you gave up on, that you were not paid, rather. You can make a complaint to the Ministry of Labor, especially in Alberta. If that's an issue you're facing in Alberta, you can make a complaint to the Ministry of Labor. They will investigate with the employer why you weren't paid your overtime. And if they find that you were, in fact, owed overtime, they will order the employer to pay you the overtime that you're owed. Okay. So in Alberta, any hours worked over 8 hours a day are supposed to be paid at time and a half. Okay. And further, if you work more than 44 hours in a week, then any hours over 44 are paid at time and a half. And those run parallel. So say you work 40 hours in a week, but you work 4 10-hour days, then you're owed 2 hours of overtime every day that you work. Okay. Say you work, I don't know, basically say you work 6 days a week, so that you work 48 hours a week, but you only work 8 hours a day, then those extra 4 hours above 44, you're entitled to time and a half for overtime pay. All right. Now, if you're a victim of workplace harassment, if you've made a complaint about it, if you reached out to someone up the management chain and said, listen, I'm a victim of workplace harassment, and they, instead of investigating that and dealing with the harasser, if they terminate you instead, then you have some claims that you can make to the labor board for having been retaliated against for having made a workplace harassment complaint. And that will open up some avenues of compensation for you, including receiving back pay from the day you're terminated until the day that the labor board makes a decision in your case. They can provide you with compensation for giving up your right to be reinstated in the job. If you want to be reinstated, they can order that you be reinstated in the job as well. And of course, you have your severance entitlements. All right. Those don't disappear. You can pursue those as well. Furthermore, if the harassment was related to something that is a protected ground under human rights, it could be your gender, your nationality, your race, your disability, your religion. There's a bunch of different things that are protected. If any of those were related, were the reason why you were being harassed, and you have rights under human rights legislation as well. So definitely, if that's something that happened to you, the best recourse is to speak to one of us at Samfiru Tumarkin, get an idea, so that we can get an idea of what happened, and then we can tell you a little bit of what your options are moving forward. So if you want to reach out to us, if you want to reach out to me or one of my colleagues, set up a consultation to speak to us about what your entitlements might be, you can do that very easily by visiting our site. We have it up there on the screen. It's employmentlawyer.ca. That's in the singular, so don't add an S, employmentlawyer.ca. That's how you reach us. Let's see here what we have. We have another question coming in from Dem Dams on YouTube. Dem Dams asks, I was forced to quit after I told my boss I needed to relocate back to the East Coast. I work a remote position and was told that I cannot move and will need to resign. Can my employer force me to resign because I'm moving? Can they require you to live in certain areas if you're a remote worker? So, Demdaz, it kind of depends if whether they can force you to work, for instance, in the province where they're located, or in Canada, or anything like that. Kind of depends on the employment agreement that you have with them. So, of course, if you're working remotely from, for instance, Alberta, does it really matter where in Alberta you're located? Probably not. But once you move out of Alberta, there'll be tax consequences, income tax consequences. There might be different laws related to occupational health and safety, workers' compensation, things of that nature, which might make an employer require you, even if you're working remotely, to work within the province where you were hired. That said, there are other employers who really don't care where in the world at all you're working. All right, but the consequence is that they have to be aware that if you move, for instance, to Europe, there's very different employment laws in Europe than there are in Canada, right? And so the same goes throughout the world. So it could be that all of a sudden you're in a different regime, in terms of legislation that applies to you. So you kind of have to look at, did you sign an employment contract? In the employment contract, did it talk about whether, even though you're remote, whether you had to work in Alberta or not? But I would say, yes, it can be difficult for you to show that although you're working remotely, that means that you can work anywhere in the world. It would be difficult for you to show that unless you have something in your employment contract that says that, which makes me return to a point I try to make a lot for people that are thinking of relocating once they're given a remote work position. Then, Daz, I'm pretty sure you had something in writing allowing you to work remotely. We saw this come up a lot during the pandemic. People that were working in the office all of a sudden were asked to work remotely, right? And some people sold their house and moved to the country. And then at the end of the pandemic, what ended up happening, the employer changed their policy back to coming into the office. And so their commute, which previously had been maybe 20 minutes, was now maybe a 2-hour commute because they were living in the country and they couldn't do that commute each way every day. So they had to quit their job, right? But if those people had gotten a guarantee from their employer when they went remote that they could stay remote, they could have claimed constructive dismissal when they were called back into the office, because now the commute had changed, right? But unless you have that in writing, that this is the policy now, you're working remotely, that's not going to change. Unless you have that in writing, it's hard for you to fight against being forced to go back to the office, all right? And especially in your case, Demdaz, if you're moving out of province, what if they call you back to the office one day or something like that, right? You'll have to quit again, right? So definitely remote positions, you want to be really clear of what that means, right? Will you ever be required to attend the office, even if it's once a month for a team building kind of exercise? And if where can you live? All right, can you live anywhere in the province, anywhere in the country, anywhere in the world? You want to have that clearly set out so that when you're making decisions about moving back east or something like that, it's very clear in everyone's mind whether you have the right to do that or not. I mean, you can do that, of course, Demdaz, but you might have to resign from your current job. So we'd have to take a look at your contract, is what I'm trying to say, and see if there's any loopholes or anything that can be exploited there. But other than that, if you're basically unable to continue to go to the job because you've relocated, then you might have no other choice but to resign and look for other work. So we really need to see your contract, see the agreement. If there's any remote work policy or anything like that, we need to take a look at that, see if we can find some grounds to argue that you should be entitled to relocate out of province. Definitely something you want to do before you start a remote position rather than once you're in it or once you've sold your house, okay? So definitely reach out to us early and often. We have a question from Juanita Breaklight, who asks, what can someone do if their employer is trying to find a way to fire them with cause? My brother's employer has been writing him up for any reason, then putting him on an unpaid suspension. So there's a few things that you can do, Juanita. All right. So firstly, if it really is these trivial things, it might be that your brother has the possibility of claiming that he's been constructively dismissed. Generally, what people understand is that there aren't necessarily the employer doesn't necessarily have a right to put you on an unpaid suspension for disciplinary reasons, all right? Unless there's something in your employment contract that says that you can be suspended for being put on an unpaid, that you can be suspended without pay, then it's just like a layoff. The employer does not have the right to do that. All right. So unless you've been agreed that you can be suspended, or unless you've been suspended in the past and didn't say anything about it, your employer, the first time you're suspended, be it with or without pay, you may have the right to claim you're constructively dismissed. The first important thing is to call us, have a consultation with us so that we know exactly why you're being suspended, and then we can talk about your rights after that. whether you're entitled to pursue severance, quit and pursue severance as a constructive dismissal. If you're trying to reach out to us, best thing to do is go to our website. We have it there on the screen, employmentlawyer.ca. All right, so reach out to us. We'll be happy to discuss that with you. However, if you don't pursue that avenue, Juanita, and your brother does get fired, and he does get fired for cause, and generally what the employer will do will refuse to pay your brother a severance package. So your brother has the right to have a judge look at that for cause termination. And if a judge thinks that what your brother did was not so serious that he could be terminated for cause, the judge will order the employer to pay your brother his severance. All right, so that's a very important thing that you need to understand. The employer doesn't have the final say whether what your brother did was so serious that it's cause for termination. All right, you can have that reviewed. All right, we do it all the time. Employers think that any little thing allows them to terminate someone for cause, and that is not the case. It has to be quite serious misconduct. I mean, if you're stealing from the company, if you're harassing, being violent at work, those are things that might get you terminated for cause. But if, as you're saying, Juanita, your brother's being written up for any little thing, and that's a classic example of an employer trying to build a case, and it doesn't work. All right, you have to have sufficient cause to terminate someone. It has to be serious misconduct. That said, one thing we always say is if you get some sort of disciplinary letter, all right, it's going into your employee file. Okay, you are at liberty to write a rebuttal to that letter. All right, you can say, listen, these are all the reasons why I don't agree with this disciplinary letter. You send it to your employer and insist that your employer attach it to your disciplinary record letter and put it in your employee file as well. All right. What I see too often is people come and see me once they've been terminated. Okay. And so the employer did progressive discipline. They gave them a first written warning, a second written warning, a final warning, and then a termination. Right. And I look at the termination, the incident that resulted in the termination, it's not too serious. Right. My client is telling me, well, here's all of these contextual factors that show that this is not too serious. But my client didn't do anything about the first three warnings, right? So you don't want a judge to think, well, if the employee didn't say anything about them, that the employee accepted that discipline was valid and correct. You want to be able to say, well, listen, this is why I don't think it's valid and correct. All right. You'll take the discipline, you'll take the warning letter, but you put your side of the story on the record as well. So when a judge sees it later, just say, well, listen, honestly, a plaintiff here or employee here was explaining to you why your discipline was all incorrect. You didn't look at the right facts. You didn't interview people that were there to get their version of events. You didn't do things right. There was an innocent explanation why the employee was late and all of that. You didn't do that. So that first discipline shouldn't have been given in the judge's view, which makes all the other discipline that followed too harsh, right? Including the termination, which strengthens your ability to then say, I'm owed a severance, even though you think you have cause to terminate me. All right. So if you feel that your employer is trying to build a case against you, put your side of the story on the record. Reach out to them, say, this is my rebuttal. This is why I think that the discipline you gave me is improper. You don't get to choose what your discipline is, right? It's your employer that chooses that. But you can put your side of the story on the record, have it in your employee file, request that employee file when you leave, and have it with you when you see your lawyer, so your lawyer can fight for your rights and get you your severance, even though the employer claims they have cause to terminate you. We do it all the time. If you need to reach out to us, we'll put the website on the screen again. If I've lost you there and you're not exactly sure and you want to reach out to us to explain the situation, that's always what's best. Reach out to us, employmentlawyer.ca. We'll be happy to speak with you, give you your options, guide you through this, because Juanita, it can be a little bit stressful and complicated, both when you're claiming constructive dismissal and when you've been terminated for cause. You want to do things right, and you want to have a lawyer in your corner helping you there. We have another question from King Koopa on YouTube. King Koopa is asking us, I was told by my employer that I would be working full-time days, and I've been doing so for the last 4 years. My workplace now wants me to switch to a morning afternoon biweekly rotation. Is there anything I can do about that? What I think you're asking me, King Koopa, I think you had, for instance, a 9 to 5 schedule 5 days a week. And now what the employer wants to do is, for instance, have you start one day, 1 week at, say, 9 or 8 to 5 or 4, and the next week start at, say, 3 p.m. and work your 8 hours that way and switch from week to week. So here's a few things that are important to know about whether your employer can change your shift like that. So that may amount to a constructive dismissal. Okay, King Koopa, just not to bury the lead. And if it amounts to a constructive dismissal, that entitles you to quit and tell your employer, listen, boss, you forced me to quit, so therefore you owe me a severance package. All right. So for that to happen, the change to your schedule has to be a substantial change to your working conditions. How do we establish whether it's a substantial change to your working conditions? First thing we look to see is there a written employment contract? If there is, does a written employment contract say anything about your schedule? Does it say, for instance, that the employer can change your schedule at will? Or does it say something in the sense that your schedule will be 8 to 4 Monday to Friday? If it says your schedule is 8 to 4 Monday to Friday, and you can argue that your schedule was an essential term of your employment conditions, they can't change it without your consent. If, however, the contract says your hours can change, at our discretion, then if you agreed to that, then they can change your hours. All right, depends what you agreed to in the employment contract. If the contract is silent or you have no employment contract, then we're looking at, have your hours been the same for the last 4 years? Have the last 4 years you've been working 9 to 5? All right. If they have, then you can say, well, that's a term of your contract. You work 9 to 5. So is this change to rotating shift, is that an essential term of your contract? So we can look at context to have a better idea. Firstly, I'd like to understand what's your main objection to working the afternoon shift. For instance, some people might have childcare responsibilities. Their kid comes home from school at 3 or 4 or 5. They need someone to take care of them. The other parent can't do it, or something like that. Then you might be able to say, well, this is not going to work for me. I can't do this. I have to be home by whatever time to take care of my family. There are other considerations, for instance, there might be medical reasons why you can't work late into the evening or something like that. Everyone is different. So if I'd like to get a better understanding of what's your issue with the 3 p.m. start. If it's just that you don't like it, you have your own family life, then you can still claim this constructive dismissal. I would say your case is even stronger if you have, an objective reason not to like it. For instance, your childcare obligations. But essentially, if you've worked the same schedule for 4 years, you don't have a contract saying that they can change your hours. That's the term of your contract. You can say, no, I don't want to do that. All right. Either you keep me on my old schedule or you terminate me with a severance package, boss. Those are your options. All right. And you can claim constructive dismissal, go after your severance. You're probably asking yourself, well, what's my severance? You can visit our severance pay calculator. We have it at pocketemploymentlawyer.ca. All you have to do is answer 4 easy questions, confidential, free of charge, no obligation. Figure out what your severance pay entitlements might be, so that you realize how much money might be available to you if you decide to tell your employer, no, I'm not doing this change. I want to stick to my old schedule. All right. So pocketemploymentlawyer.ca. Find out how much severance you're owed. All right. We have another question coming in from YouTube from user Peaceful Relaxation. Peaceful Relaxation is asking us, what kind of employment rights do people who are employed by the Canadian Navy have? Do you receive severance if they let you go? So that's a great question, Peaceful Relaxation. Canadian Navy, Canadian Armed Forces, my understanding is that there are special laws and tribunals for them. So they don't go through the court system. All right. So basically, lawyers represent mainly or exclusively non-unionized workers, and Canadian Armed Forces are dealt with through the Armed Forces judicial system. All right. So I 99% sure that soldiers, Navy personnel, if it's part of the armed forces, you can't go through the courts. Therefore, you can't have a lawyer represent you in that regard. All right. You can potentially, if there's like a court martial or something like that, have a lawyer represent you for that. But to pursue your severance entitlements, you'd have to look at what the law says for the Canadian Armed Forces. It doesn't necessarily, translate that you can look at, what a non-unionized employee got in a provincial context and get the same entitlements if you're involved as a soldier, as a Navy personnel or anything like that. All right. We have an email question from Lou. Lou is asking us, can my employer fire me for needing to take time off to deal with a family emergency? Are they allowed to require a doctor's note for me for things like this? Depends what you mean by family emergency, but no, they can't fire you. No. So generally, we represent non-unionized employees in British Columbia, Alberta, and Ontario, and all three provinces have special leave provisions for family emergencies. Like I said, it depends on what the emergency is, but usually, if they're medical emergencies dealing with someone that's related to you, either a child, a spouse, or a parent, then there is some time off provisions, and those leave provisions have a protection for return to work, that you can't be fired for having taken that leave. And then once you're done with that leave, you have to be returned back to your position that you had before the leave, or to a similar position if that old position no longer exists. All right. So those leaves are governed by the employment standards legislation in the province in which you live. You can find those online for instance, visiting the Employment Standards branch of the Ministry of Labor in the province where you work. So if you work in Ontario, the Employment Standards branch of the Ministry of Labor for Ontario; in Alberta, the Employment Standards branch of the Ministry of Alberta. Same thing for BC. And they will detail all the leaves that you have available to you as an employee in a non-unionized context in that province. All right. So one of them is family emergency leave. Definitely. We have a question coming in from Sam. Sam is asking us, sir, does your company or organization provide a service for being able to draft and form an employment contract from the perspective of a potential employee? Absolutely. Yeah, we do it all the time. So generally, people will come to us, their employer will have provided them with an employment contract, and we're asked for our opinion on this contract and what we think should be changed in the contract. All right. Other times, employees will say, well, I don't have an employment contract. I want to propose one to my employer. All right. And see if my employer will sign it. And we can draft a contract from the perspective of the employee. This is going to be a contract that, if you haven't started the job, we'll say, what your job conditions are. If you've already started the job, we can kind of write down what the job conditions are. And if you can get your employer to agree that those are the job conditions, then you sign the contract, and now you have your job conditions are kind of official, if you will. I always warn people, though, you got to think about the pros and cons of having a written employment contract. All right. So a lot of the contracts that we see are drafted by the employer, and anyone who reads them knows that they're basically there for the benefit of the employer. All right. You read them, they're very one-sided. They're there to protect the employer's rights and to limit the employee's rights. And the reason they're there is because in the absence of a written employment contract, employees still have rights. They have a lot of rights. All right. It's not because you don't have a written employment contract that you don't have rights. You still have a lot of rights. Your rights are included in the laws of the province that you work in, employment standards regulation. In the courts have laws called the common law that protect employees as well. So there's a lot of laws, even in situations where there isn't a written employment contract. And in fact, what most written employment contracts try to do is to get you to agree that you won't rely on the laws that are there to protect you. And that can be illegal in certain circumstances, right? So you got to watch out, because What employers are trying to do with an employment contract is limit your rights, limit your entitlements. They're trying to put in non-competition clauses so you can't find work when you leave. They're trying to put termination clauses so you don't get as much severance if you're terminated. A lot of things that are generally not to your benefit. So if you're presented with an employment contract, it makes a lot of sense to have it reviewed by a lawyer, because you got to understand what you're signing, right? It can have a lot of impact on what you are entitled to while you're working and what happens after you're let go. So like I said, it's better to know going in what happens when you're terminated than finding out when it's too late. All right. So definitely worth checking out and reaching out to us about that. Sam has a follow-up question. Let's see what Sam is asking us. What would be an appropriate outlining or scope of the intention of being able to draft such a contract for reemployment within the same organization for a non-exempt worker? So I guess what you're asking me, Sam, is what kind of clauses would I put into the employment contract? If I were to draft one for an employee, I'm trying to make sure that firstly, when you're working, that they can't make just any change they want to your working conditions. We had a question earlier today about what happens if my employer changes my shift. We don't want that, right? We want to make very clear what the shift is so that they can't change it. We don't want to give them the right to relocate you hours and hours away. We don't want them to have the right to change your duties. We want to have a list of duties so that they don't just change your duties and change your job description. Then we want to make sure that you don't have a non-competition agreement so that if you need to leave, you can go work for whoever you want. If you are terminated, you want to make sure that there's a contractual provision providing that you'll be given fair severance. These are the kind of things you want to make sure are in there. What you want to make sure is not in there is anything that limits your reemployment obligation, that gives them the right to change your working conditions and stuff like that. That's definitely something you want to avoid, right? If you want to keep as many of your rights for yourself rather than sign them away. So that's definitely what we're looking at, Sam. Now, I'm realizing we're run out of time, and I just want to thank everyone for having joined us today and asked your questions. We had some great questions today. Thank you, everyone. I hope you enjoy the rest of the week. We are back here tomorrow. My colleague Darren Saul is here to take your questions at 1 p.m. Pacific time. So if I didn't get to your question, or if you have follow-up questions from what you heard today, feel free to speak to Darren tomorrow. He'll be happy to take your questions, as was I. So I hope you enjoy the rest of the day, and we'll see you soon.